Hello, everyone. My name is Karen Steward. I'm a lawyer at the Advocacy Center for the Elderly, and I'll be presenting today with Executive Director Graham Webb.
Hello, everyone. I am Graham Webb, and thank you for joining us for our Town Hall series on aging gracefully, addressing the topic when someone can legally make decisions for you.
We'd like to start the presentation by acknowledging that it's being made from the territory that's covered by the Dish with One Spoon Wampum Belt Covenant, which was an agreement between the Haudenosaunee and Anishinaabe to share and care for the resources around the Great Lakes. We invite you to acknowledge the territory from which you engage with us today and to express gratitude for the nations that have protected the land. This is part of our responsibility to educate ourselves and actively engage with the calls to action of the Truth and Reconciliation Commission to end centuries of colonialism that is still ongoing today. So we'd just like to do a brief disclaimer, because we're lawyers, that this presentation is legal information for educational purposes and is not legal advice. If you need legal advice for a particular situation, please consult your own legal advisor.
If I may say a word about our clinic, the Advocacy Center for the Elderly, we're a community legal clinic under the Legal Aid Services Act. We were established in 1984, and we were the first legal clinic in Canada serving low-income seniors. We're a fairly small office. We have 6 lawyers, 3 paralegals, and an administrative coordinator. We're a nonprofit charitable corporation. Our mission is to uphold the rights of low-income seniors and to improve the quality of life for seniors by providing direct legal services, which includes direct client assistance. We do the same things other lawyers do in advising and representing older adults who qualify for our services, by giving public legal education sessions, of which today's presentation is part of our public legal education mandate. Law reform activities. For example, we will be making submissions on the upcoming bill concerning long-term care in the Ontario legislature, community development, and community organizing.
So today's topic deals with when another person can legally make decisions for you. And the short answer to that question is that as long as you are mentally capable, you make your own decisions. Someone else can make decisions for you when you become mentally incapable of making a particular decision. There's a little exception with powers of attorney for property. For example, my dad is mentally capable of making property decisions, but he's made a power of attorney for property while he is abroad so that I can make some banking decisions for him while he's gone. So he is still capable, and that doesn't take away from his ability to manage his own finances, but I can also have that legal authority while he is still capable. Mental capacity is a legal concept, and there's no single definition of capacity. Each particular task or decision has its own corresponding capacity characteristics and legal test. There are 4 of these tests that we're going to go through in our conversation today. We're going to be talking about a piece of legislation called the Substitute Decisions Act. That's the act that largely deals when a person becomes incapable, who can act as their substitute decision maker. And there are 4 of these capacity tests defined in that act, which we are going to review today. Capacity is not a physical or sensory capacity. It doesn't have to do with if you're not able to have the mobility to go to the bank. That doesn't impact your mental capacity. Same thing goes with other types of sensory issues or physical issues, such as vision or hearing. Those don't impact your mental capacity to make a decision. As well, it doesn't depend on your age. Age is not a proxy for capacity. Capacity is decision time and situation specific. So it depends on the type of decision you're going to make. So property decisions, personal care decisions, making a will, the test for capacity is different depending on what the decision is at issue. And the same time is also impacted by capacity. A person may not be capable in the morning before they take certain medications versus the afternoon, or if they have a particular illness that causes them to have capacity at different times. Same thing with, as I mentioned, situation specific. A person may have capacity when they're undergoing this assessment in their home versus at a lawyer's office. And so this means that a person may be capable with respect to some decisions at different times under differing circumstances. And so, for example, a person might be capable of making treatment decisions for themselves, but incapable of making property decisions. And it can get really granular as well. You could be capable of consenting to treatment to or not capable of consenting to treatment to a psychiatric medication, for example, but capable of consenting to the side effect medications. I don't know if Graham, if you have anything to add.
Well, if we can go on to the next slide, I'll just say that on the first of these four tests is the mental capacity to manage your own finances. And as Karen said, this is a legal test. And so what we do is we look at, what the facts are and we apply it to the legal standard. And in Ontario, the legal standard of capacity to manage finances is two parts. The first part is the mental ability to understand information that's relevant to a property decision. And the second element is the mental ability to appreciate the reasonably foreseeable consequences of making or not making a decision. So, in the first part of the test, if you don't know, say, what your property consists of because you have never had access to that information, that doesn't mean you're mentally incapable of understanding it once you gain access. And also, there's many people who never lose mental capacity to manage finances or anything else except for perhaps a short time towards the end of your life. For example, if you're suffering from a terminal illness and you are going through palliative care, you might lose mental capacity for a period of days, weeks, or months before you pass on. You might lose capacity earlier in life, but there's a great many people who never lose capacity right to the day they die. Next slide, please.
And so, as we mentioned, there's different factors that go into the different capacity tests. And so this is the test that's set out in the Substitute Decisions Act for the capacity to give or revoke a power of attorney for property. If you're capable of giving it, the same test applies to revoking it as well. Like the other test that Graham just mentioned, this test involves knowledge and appreciation. And with all the capacity tests, it doesn't mean people are free to make bad decisions or decisions that other people would see as being unwise. And that doesn't necessarily mean they don't have capacity. So when we're talking about the capacity to give or revoke a power of attorney for property, it has these 7 factors: knowledge of your property and its approximate value, awareness of obligation to dependents. And that doesn't necessarily mean you are giving your money to dependents who require it. It's an awareness of the obligation. Knows the power of attorney. I actually think maybe we lost something there on that part of the test. Knows the attorney has a duty to account. Knows that the power of attorney can be revoked. Appreciates that the attorney could mismanage the property, and appreciates that the attorney could financially abuse the grantor of the attorney. So there's an appreciation that this could happen. And like I mentioned earlier, you can be capable for some aspects of decisions and incapable for others. So the validity of your power of attorney for property doesn't depend on you being capable of managing your own money. Yeah, do you have anything to add, Graham?
Well, just the Substitute Decisions Act, the law of Ontario, expressly states that even if you are mentally incapable of managing property, making your own property decisions, you can still be mentally capable of giving or revoking or canceling your power of attorney if you meet this test of capacity to give or revoke.
And so I would also add assessments of capacity to give or revoke continuing powers of attorney for property don't need to be made by capacity assessors. And I'm going to talk later about capacity assessors. But generally, if you're going to see a lawyer who's preparing these documents for you, it's that lawyer who will make this assessment of your capacity. Sometimes if a person's capacity is in question, that lawyer may suggest that the person obtain a more formal assessment, which is intended to ensure that the client's autonomy and decision making is safeguarded should that power of attorney be challenged down the road by someone who claims that they didn't have capacity at the time it was made.
When we're speaking of a quote power of attorney, we're actually speaking of a document. It's a document in which someone who makes the power of attorney is naming another person. The person is known as an attorney, or you think of it as an agent, someone acting on your behalf. In this case, to make property decisions, it's a power of an attorney for property. And the power of attorney document gives authority to that person to make financial decisions on your behalf. And this document, unless it says otherwise in the document, it takes effect as soon as it's signed. And, most people just don't appreciate that. They don't know that as soon as they sign the power of attorney, that the person you've named can withdraw money from your bank account, and so can you if you're still mentally capable of doing so. And the person you've named can sell or mortgage your house, cash in your mutual fund, all those things. It's giving that power right away, unless you do something in the power of attorney to give it delayed effectiveness, which Karen will speak to in a minute. And this power of attorney can be a continuing power of attorney so that it carries on even later if and when you become incapable. And this power of attorney document is the first of 3 methods that you could use to give someone else the legal authority to make financial transactions on your behalf if and when you should later become mentally incapable of making your own property decisions.
And so Graham mentions when does the continuing power of attorney take effect? And so the general rule, like Graham said, is as soon as you sign it, unless it states otherwise. The document can also contain a condition that it becomes effective when a certain event happens. So this document only becomes effective when I am incapable of managing property. And as well, the document can state the method in which incapacity is to be determined. For example, it could say, when my family doctor, Dr. So-and-so, says I'm incapable, or a certain class of professionals like a psychologist, or it could be a particular person, my best friend. If it doesn't state who or the method, then the automatic class of people to determine that incapacity is a designated capacity assessor. And these are particular professionals who have undergone training by the Ministry of the Attorney General. They're insured. There are different classes of health professionals like psychologists or social workers or physicians, that there's a roster kept by the Ministry of the Attorney General at the Capacity Assessor Office. So If you don't say anything about it, it comes into effect right away. If you can name a particular event and you can name a particular method of assessment. It's just important to consider that if you do name a particular person, that you just consider any potential delay or cost associated with obtaining that independent evidence of incapacity.
This is a part of the answer to the question, what would happen if you don't have a power of attorney for property in place and you lose mental capacity to make your own financial decisions? You know, back in the day, and I'm speaking prior to May 1st, 1995, if you didn't have a power of attorney in place and somebody needed legal authority to manage your finances, then that person would have to go to court under what was then the Mental Incompetency Act and to apply to be what was then called your comité of property. Prior to that, they used to call it the Lunacy Act. In 1995, we had law reform, which created a new way for someone to obtain substitute decision-making authority over your property if you don't have a power of attorney for property in place and if you should lose mental capacity. And this is called the statutory guardianship. This is the second of three methods that someone can gain decisional authority for you. And the reason it's called a statutory guardianship is because it's a guardianship that's created by operation of statute without a court order. The process is that if you are not a patient in a psychiatric facility, then the process is someone can arrange a capacity assessment of you by a designated capacity assessor. The designated capacity assessor must inform you of your right to refuse the assessment. You don't have to consent to it. You simply have the right to refuse. And if you don't refuse the assessment and the assessor finds you mentally incapable of managing your finances, then the assessor will send a document called a certificate of incapacity to the Office of the Public Guardian and Trustee. Then, by operation of statute, the Office of the Public Guardian and Trustee would have full legal authority to make financial decisions on your behalf. But the last thing the Public Guardian and Trustee wants to do is to manage your finances. They also have legal authority to delegate that guardianship to a family member who applies for it. And so your spouse or partner or your son or daughter or your brother or sister could apply to become your statutory guardian in place of the public guardian and trustee. For a person who is a psychiatric patient in a psychiatric facility, the Mental Health Act provides that that person must be assessed as to their capacity to manage finances by a physician when they enter the facility. If the physician finds they are not mentally capable, then the same process applies. A certificate of incapacity is sent to the Office of the Public Guardian and Trustee under the Mental Health Act, and the process is exactly the same, with the exception that when the person is discharged from the facility, the physician must again examine the person. If the physician feels that the person is still mentally incapable of managing property, then the physician will send a different document called a notice of continuance to the public guardian and trustee, notifying them that the statutory guardianship should continue even though the person has been discharged from hospital. Otherwise, the statutory guardianship will end when the person leaves a psychiatric facility. One of the main differences between the statutory guardianship and the power of attorney for property is that when a power of attorney for property is given, it doesn't stop the person who gave it from continuing to make their own financial decisions. When a statutory guardianship or a court-appointed guardianship is created, the person who is the subject of the guardianship no longer has the legal authority to make financial transactions on their behalf, on their own behalf.
And I would just add that in both cases of statutory guardianship, the person who has been assessed as incapable can apply to an administrative tribunal called the Consent and Capacity Board to have the finding of the physician or the capacity assessor reviewed. And that's an administrative tribunal called the Consent and Capacity Board.
In general, whenever there's a decision that takes away someone's right to make their own decisions, there will usually be some sort of review or appeal mechanism for that.
And so as Graham went through the first two methods of substitute decision-making for property, the last one is court-appointed guardianship. This is the most intrusive and expensive method, and it's not the most common because of how expensive it is. It's a court application to the Superior Court of Justice, and the Substitute Decisions Act lays out how that application is to be made, what documents are required, and generally people require lawyers to make this application, which is what makes it more expensive. And it's created, the guardianship is created when the court finds that the person is financially incapable, that they need a guardian of property, and that there aren't any less restrictive courses of action that are appropriate and available. Unlike the public guardian and trustee, the court is not limited in who it can appoint. Although a person who's paid to provide services to the incapable person is generally prohibited from being the guardian unless that person is their spouse, partner, or family member. The court also has the exclusive authority to appoint a guardian to replace an attorney under a power of attorney for property. In making its decision about who should be appointed guardian, the court considers whether the proposed guardian is the acting attorney under a continuing attorney for property, the incapable person's wishes, if they can be ascertained, the closeness of the relationship between the proposed guardian and the incapable person. And this type of guardianship will only end if the incapable person dies, the guardian dies, or the court makes an order terminating the guardianship.
There are times when a person is mentally incapable of making their own property decisions, but they don't actually need a guardian. And the court should not appoint a guardian if one isn't needed. And so the first situation is if the person already has a valid and subsisting continuing power of attorney for property. So a statutory guardianship is not available if the person does have a valid and subsisting continuing power of attorney for property. A court-appointed guardianship could be available, but only in circumstances where the court feels the power of attorney is being abused, or for some reason that the attorneyship needs to be ended. Also, there are cases where someone has really no substantial assets that requires an attorneyship or a guardianship. For example, if someone is living in a long-term care home, they don't own any real estate, they have no substantial financial assets that would need legal authority to deal with, and their only income consists of the old age security pension, the guaranteed income supplement, the Canada Pension Plan retirement or survivor's benefit, then those federal income security payments can be administered under a federal income security trusteeship, which is a bit of a separate topic that we don't really have time to go into today, but someone can apply to become the trustee of the person's federal income security payments.
So powers of attorney and guardians of property. The attorney or guardian in general has legal authority to do anything in respect of property that the incapable person could do except make a will. And that is a massive amount of authority that could be given to a person taking out loans, selling a house, controlling your pension. The powers can be limited by conditions and restrictions in the power of attorney document or in the court order appointing a guardian. So conditions could include, for example, that the attorney needs to consult with specific people like a family member or a financial advisor before making a decision, or specifying the type of investments your attorney can make on your behalf, or requiring your attorney to give priority to certain people in making loans or gifts on your behalf, or even specifying how disagreements are to be resolved if you name more than one attorney. A guardian of property is entitled to any personal information, including health information about the incapable person. As well, power of attorney documents, the continuing power of attorney for property can be limited. For example, you could limit it so that your attorney can only deal with transaction concerning specific assets, but you would want to turn your mind to whether, should you become incapable, what would happen with the rest of your assets or property.
Until now, Karen and I have been speaking in fairly great detail about property decision making, and now we'd like to speak specifically about personal care decision making. And what's in front of you on the screen is the third of 4 tests of mental capacity found in the Substitute Decisions Act. It's the test of mental capacity to make your own personal care decisions. And once again, this is a 2-part test. It revolves around your mental ability to understand information and your mental ability to appreciate the reasonably foreseeable consequences of making or not making a decision. In this case, the information that you need to be able to understand is information concerning your health care, nutrition, shelter, clothing, hygiene, or safety. These are what are commonly known as the spheres of personal care decision making.
And so the final of the 4 tests that are set out in the Substitute Decisions Act is the capacity to give or revoke a power of attorney for personal care. And here the test is whether you have the ability to understand whether the proposed attorney has a genuine concern for your welfare and appreciates that that person might have to make decisions on your behalf. And so, like with property, a person who is incapable of personal care decisions can still be capable of giving or revoking a power of attorney for personal care. Sometimes in these documents, people will express certain treatment directions or wishes. For example, I don't want a particular class of medication. And if you do put that into your document, you have to be capable of that decision at the time that the power of attorney for personal care is executed.
We'd like to speak about the power of attorney for personal care document. The power of attorney, once again, is a legal document. The person named in the power of attorney is the attorney for personal care. And all of this, almost all of this, is very similar to a power of attorney for property, except that instead of dealing with property matters, it's dealing with personal care matters. The most important difference is that unlike the power of attorney for property, which comes into effect as soon as it's signed, unless the document says otherwise, the power of attorney for personal care comes into effect only if and when the person becomes mentally incapable of making their own personal care decisions.
And so one thing that Graham and I haven't talked about yet, but maybe this is a good place to talk about it, is choosing the right attorney. Choosing the right attorney is an important step in reducing the risk of future abuse and whether or not you even want to make this type of document. And trusting any potential attorneys is key because continuing powers of attorney for property and personal care are far-reaching documents that can impact some of the most vital aspects of your life, where you live, what you eat, how your money is managed, and just considering the extent of the powers that are given and whether the person or people who you name will truly look out for your best interests.
I think everyone should understand that you don't necessarily have to have a power of attorney. Because if you don't have a power of attorney for property or for personal care, and you should lose mental capacity to make your own property or personal care decisions, there will probably be someone else to make that decision for you if the need arises. And so these should be optional types of decisions for you, whether to have a power of attorney in place.
And so at ACE, I can just say, for example, we've seen cases where people are considering going to rent in a retirement home, and the landlord in the retirement home says, oh, you need to sign a power of attorney before you become a tenant here, and why don't you name your daughter? She's sitting right beside you. And a person might feel, okay, I have to do this and sign that document without really considering the unintended consequences and how powerful that document might be. And so Graham touched upon this a little bit. When is a power of attorney for personal care effective? And so like he mentioned, unlike the continuing power of attorney for property, it's only effective when you become incapable. What's tricky about powers of attorney for personal care is there's sort of two types of decisions that have different ways of becoming effective. And so the first group are certain decisions that under a piece of legislation called the Healthcare Consent Act. And that's generally treatment decisions and admission to long-term care home decisions. And so for those decisions, when that legislation is triggered, and so we're going to talk about it more later in the discussion about when is a treatment decision, are you considered incapable of making a treatment decision, for example, that's when your power of attorney for personal care will become affected, once those decisions are triggered and you're found incapable under that legislation. For all other personal care decisions that don't come within the scope of the Healthcare Consent Act, and so we're talking again about nutrition, shelter, for example, it's when the attorney for personal care believes that the grantor is incapable, unless your power of attorney document says otherwise. If you name a particular person to assess your capacity for these other personal care decisions, once that assessment is undertaken, then it will be triggered. If you do say that it can have a condition to confirm a capacity by a capacity assessor, and if it, sorry, I think I've sort of stumbled my words. If you say that it does need to be triggered and you don't say specifically who, it will be a designated capacity assessor. Or you could name somebody in particular. Otherwise, it's the grantor who makes that assessment of whether the power of attorney for personal care should be triggered.
I'd just like to correct you, Karen. I think you said grantor,
sorry.
but you probably meant to say attorney. Because I think this is one of the gaps in the Substitute Decisions Act, is that if you give someone your power of attorney for personal care and time passes and you think you're still mentally capable of making your own accommodation decision, say whether you want to go into a retirement home or such thing, and your attorney for personal care thinks you aren't, then it's your attorney for personal care who decides whether you're mentally capable of making that decision. And unlike all of the rest of the instances in the Substitute Decisions Act and the Healthcare Consent Act and the Mental Health Act, where a decision making a decision is forced on you, there is no appeal mechanism. There's no review board for the Consent and Capacity Board to decide if your attorney for personal care has made the right decision when they form the opinion that you're no longer mentally capable of making your own personal care decisions. And that points to how very powerful these documents are. Our colleague Jane Meadus is one of our institutional advocates, and for years she used to have a sign on her office door, she's taken it down, that said, be nice to your children, they'll pick your nursing home. And this is true. And sometimes people think giving a power of attorney for personal care is like a consolation prize. You know, they have someone in mind to manage their property and someone else in mind whose feelings they don't want to hurt. And so they give them the power of attorney for personal care instead. But you couldn't make a greater mistake, because the power of attorney for personal care is even more powerful than the power of attorney for property. And if you're in doubt as to who to give it to, the best thing to do is to probably not give one at all. This is the second of two methods for granting authority to make personal care decisions on your behalf. Unlike with property, there is no such thing as a statutory guardianship of the person. You just can't get an assessment of capacity to make personal care decisions and have the PGT take over as your guardian of the person. It doesn't work that way. The two methods here are a power of attorney for personal care or a court-appointed guardianship of the person. And this is again thought of as the nuclear option, where if you don't have a power of attorney for personal care in place and somebody needs authority to make personal care decisions for you, then that person would have to apply to the Superior Court to become your court-appointed guardian of the person. It's a very usually expensive and sometimes very divisive process. But fortunately, in most cases, people don't need a court-appointed guardianship of the person, because if the decision relates to treatment, anything done by a regulated health practitioner for a health-related purpose, or for admission to long-term care, or for personal assistance services within a long-term care home, then there is another way of someone having decisional authority under the Healthcare Consent Act that Karen will speak to next.
And so treatment decisions and admission to long-term care and personal assistive devices in a long-term care home are covered under the Healthcare Consent Act. And so under this act, substitute treatment decisions can be made even if you haven't made a power of attorney for personal care, and even if you don't have a court-appointed guardian of the person. There's a list, a hierarchy of substitute decision maker that only applies to these type of decisions. And so you start at the top of the list and work your way down until there is a substitute decision maker who is capable, available, and willing to make a decision. So if I'm the doctor proposing a particular treatment to a patient and I have a concern that that patient is not capable of making that decision, I'm supposed to go through that list, start at the top, work my way down to find the appropriate substitute decision maker. And when there are more than one equally ranked decision maker, they have equal authority. And if there's a disagreement between these equally ranked decision makers, the public guardian and trustee can mediate or make the decision on their behalf.
Sometimes people think that it's majority rules. You know, for example, if the decision maker is your child or parent, and you have 3 children and 2 of them will want one thing and one wants the other, it's not a case of majority rule. They all have equal decision-making authority. And so then that's a deadlock, and it goes to public guardian trustee, who will first try to mediate among the disagreeing decision makers to follow the correct principles of substitute decision making, which we will speak to shortly. Or if they can't agree, then the public guardian and trustee has the legal authority. And so this is really the heart of the at the heart of the substitute of the Healthcare Consent Act. It is the list of who will make a decision for you on treatment, admission to long-term care, or personal assistance services within a long-term care home if you are not mentally capable of making that decision yourself. So the first on the list is a court-appointed guardian of the person with authority to make the treatment decision. Not many people have a court-appointed guardian. This very rarely happens. If it does happen, the court appointment could be for a full guardianship or a partial guardianship. And if it's a partial guardianship, the guardianship order may not include authority to make the particular treatment, admission, or personal assistance service decision that's in question. Now, what's important for everyone to take really good note of is what's number 2 on the list. Number 2 on the list is an attorney for personal care with authority to make treatment decisions. If you give someone your power of attorney for personal care without conditions or restrictions, then that person is the second highest ranked decision maker for these really important decisions: treatment, admission to long-term care, personal assistance within a long-term care home. And the only thing that trumps an attorney for personal care is a court-appointed guardian of the person, someone who has the means, the financial means and the willingness to go to court to ask for a court order to become your court-appointed guardian of the person. So these powers of attorney documents are not candy to give to children. They're very important legal documents. What happens if you don't have a power of attorney for personal care? Well, the next category would be a board-appointed representative. This is someone who hasn't gone to court, but has made an application to an administrative tribunal, the Consent Incapacity Board, to be appointed your representative for that particular decision or category of decisions. The next on the list would be your spouse or partner. Spouse means your legally married spouse or your common law spouse. It makes no difference. Partner includes a person with whom you have cohabited for at least 1 year in a relationship of primary importance to each other. Next on the list would be your child or parent, not including well, we're not worried about access only because, here the persons who are making decisions for are older adults, right? So my mother passed away at 98 years of age this past summer. Before she passed away, she was always useful for these examples because I have 4 sons and 3 daughters, all of whom are adults now. And while my mother was alive, my mother, who reached 98 years of age, and my 7 adult sons and daughters would have been in the same category of parent or child. And as I said before, it's not majority rules. If everybody but one person asserts decision-making authority one way, and the 8th person goes the other way, they're deadlocked, and it goes to the public guardian and trustee. And it's not the oldest to the youngest or anything like that. They all have equal authority. I'm going to skip access only parent. The next is your brother or sister. The next is any other relative by blood, marriage, or adoption. And to be perfectly honest, I've been practicing this law from the day that the Substitute Decisions Act came into effect in May 1995, and I still don't know the full extent of this legal definition. Certainly we know by blood and adoption are equivalent. There's no difference between blood and adoption, right? But how far does blood go? Blood would include, it includes necessarily your child or your parent, would also include, I think, your nephews and nieces. Would it include your cousins? I don't know, perhaps. What about by marriage? Marriage doesn't mean your spouse or partner. It means someone else you're related by marriage by. So would it include my sister's husband or my wife's sister? There's a lot of room in there. And if you have nobody else in Ontario who or out in the world who could act for you, it becomes the Office of the Public Guardian Trustee, the Treatment Decision Unit. And I'd like to pause here again to reflect on the importance of the power of attorney for personal care. Let's say that I had not given the power of attorney for personal care, then by default, this list of decision makers might reflect the persons who are probably closest to me to make those decisions. If I couldn't decide, my wife could decide. If my wife weren't available, then any of my 7 children could decide. They don't have to all assert decision-making authority. If one asserts decisional authority and nobody else objects, that's good enough. If more than one of them assert and they agree, that's no problem. If they disagree, then the public guardian trustee intervenes. Now, what if I had given a, what if I had given a power of attorney for personal care and the person I'm giving it to is simply making the wrong decisions? Maybe they're making abusive decisions. It's difficult, if not impossible, to get rid of that person except by going to Superior Court. It also forecloses the opportunity for a board-appointed representative. If my wife and I were both mentally incapable and my kids wanted to put me into a long-term care home against my will and I hadn't given a power of attorney, I could ask my best friend, I could say, Mike, I need you. I need you to become my representative for my long-term care admission decision. And then my best friend could could make an application to the Consent and Capacity Board to be my board-appointed representative for my admission to long-term care decision. But my best friend could only do that if I had not already given a power of attorney for personal care, because a power of attorney for personal care trumps everything except for a court-appointed guardian.
And so for all of those potential decision makers in that hierarchy, they have to be capable themselves in respect of the treatment that's proposed. They have to be at least 16 years old, unless they're the parent of the incapable person, not prohibited by a court order or separation agreement from acting as a substitute decision maker. And so it says SDM, that's a short form for substitute decision maker. They have to be available, and available in the legislation means that the person is available, if it is possible, within a time that's reasonable in the circumstances to communicate with the person and obtain consent or refusal. So these days, especially with Zoom and the technologies that have come about because of the pandemic, people can be available even though they might be in another place. And they also must be willing to act as substitute decision maker. So as long as the highest ranking person on that list is capable, available, and willing to act, then the physician or the person proposing the treatment should take substitute instructions from the highest ranking person that meets these requirements.
It may seem illogical or counterintuitive, but when an attorney or guardian of the person or another substitute decision maker under the hierarchy is making a treatment, admission, or personal care decision, the first rule is not to act in the person's best interest. The first rule is to follow the incapable person's last capable wish that would apply in the circumstance. And if there is no last capable wish that would apply in the circumstance, only then does the decision maker, whether it's an attorney, a guardian, or a person named in the hierarchy, have to turn their mind to what is in the person's best interest.
And so best interest actually is a legally defined test set out in the legislation. If you're acting as a substitute decision maker for a person, it's not what you would want. What you have to go through this list and to determine best interest. So like Graham said, first you determine if there's a prior capable wish that applies to the circumstance. If not, then you consider the values, beliefs, and any other wishes expressed by the incapable person. Whether the treatment is likely to improve the condition, prevent it from deteriorating, reduce the extent of or rate of deterioration. You have to consider what would happen if there is no treatment. Would the person likely be better, the same, or worse? Do the benefits outweigh the risk? Are less intrusive, restrictive treatments just as beneficial? And so that's where really knowing the person comes into play, especially knowing what their values, beliefs, who they are, what they would have wanted, and taking that into consideration in formulating whether this decision is in their best interest.
If you are called on to make a treatment decision on your own behalf for yourself because you're still mentally capable, or if someone else is called on to make that decision on your behalf because you are no longer mentally capable of the treatment decision, you or your substitute decision maker has a legal right to receive information from the health practitioner who's proposing the treatment. And that information really reflects the best interest criterion that Karen just spoke to. In other words, what is this treatment about? What are the good things that should happen because of this treatment? What are the risks? What are the side effects? What else can be done? And what happens if I don't have this treatment? And that's information as your own health advocate you could follow in making your own healthcare decisions. And if you're a decision maker for another person, it's your legal obligation to get that information and to consider these factors.
And so the general rule when we're talking about treatment decisions is that the health practitioner who's proposing the treatment must get informed consent from you if you're capable, and from your substitute decision maker and the appropriate one on that hierarchy that we went through if you're not capable of making that decision. There's an exception to that, and it should be the rarest of circumstances if an emergency exists. And that is when a person is experiencing severe suffering or is at risk of serious bodily harm. In that circumstance, treatment can be given without consent, where the delay to obtain substitute consent or refusal of consent would prolong suffering or risk serious bodily harm. This treatment is available where the person is capable but not able to communicate due to a language barrier or disability. But again, like I said, this should be the exception because the general rule in Ontario is that informed consent must be received before treatment, either from you or for your substitute decision maker.
And just to be clear, it really doesn't matter if the person is capable or incapable. It may be that the person is obviously incapable of giving or refusing their own consent, perhaps because they're unconscious. You're not able to do that. In that case, emergency treatment is available where these criteria exist. Let's say there's no reason to think you're not mentally capable, but you can't speak because of something that's happened in an accident, or you can speak, but nobody can understand the language that you're speaking. Then emergency treatment is available even without consent. Now, whether someone becomes a decision maker because they're an attorney for personal care under a power of attorney for personal care, or a court-appointed guardian of the person, they have similar authority. If it's a attorneyship, the person is then authorized to make personal care decisions and treatment decisions only if and when the person who gave the power of attorney becomes mentally incapable of making their own decisions. If a court-appointed guardian of the person is appointed, the court will have already made a decision that the person who was under guardianship is in law incapable of making their own decisions. And the guardianship may have more extensive powers. It can include a custodial power to make decisions about safety and things like that could involve confinement that is not available to an attorney, access to personal information, personal care and treatment decisions as with an attorney for personal care, and any other decisions authorized in the court order. Sometimes people say that really the power of attorney contains no real powers, just contains duties. And so we should look at the duties of both attorneys and guardians of property and personal care.
The powers and duties of an attorney or guardian, the legislation sets out that these shall be exercised and performed diligently and in good faith. And so when we talk about fiduciary duties, a fiduciary is a person who holds a legal or ethical relationship of trust with another person. An attorney or guardian of property has a fiduciary duty in respect of the incapable person's finances. So, for example, fiduciary accounting is the legal duty of the guardian or attorney to maintain good, detailed, understandable financial accounts and records of all transactions involving the person in the management of their property. And they have to act in accordance with the legislation, which is the Substitute Decisions Act, its regulations, and if it's a court-appointed guardianship, a court-approved management plan. And the regulations in the Substitute Decisions Act set out the specific components and forms of accounts and records that are to be maintained.
If someone is managing an incapable person's finances under a continuing power of attorney for property or under a statutory guardianship or under a court-appointed guardianship, then that person who's the attorney or guardian must manage the incapable person's property in a way that's consistent with the personal care decisions that are made by the person who has legal authority to make personal care decisions. What the heck does that mean? Well, that means that someone might be completely mentally incapable of making their own financial decisions and have an attorney or, be under attorneyship or guardianship, but they might still be mentally capable of making their own personal care decisions, such as where do they want to live. Then the attorney or guardian has to manage the finances in a way that is consistent with the person's own capable decisions about where they want to live, whether they want to live in an apartment or whether they want to live in a retirement home, those sorts of things. Also, in a case where a person has given a power of attorney for property to one person and a power of attorney for personal care to another person, then it's the attorney for personal care who decides the personal care decisions, and the property decisions that are made by the attorney or guardian of property have to follow suit. It's rather like a dance where the attorney for personal care leads the dance and might say, and a conversation might go like this. The attorney for property, let's say brother, says to the attorney for personal care, let's say sister, I think father's not managing well in his home. He's requiring too much care and it's too expensive. I think we need to move him out of the house and put him into a retirement home or a long-term care home to save costs. And sister might say, brother, I think dad should stay in the house. He loves living there. He has enough means to stay there, and that improves his quality of life. I think dad should stay in the house longer. And brother might say, well, if he stays longer, he might run out of cash. We might have to collapse some investments to keep him going. And sister might say, brother, I'm dad's decision maker for his personal care decisions. He entrusted that to me. It's my decision that dad's staying in the house. So you do whatever you have to do by collapsing his investments or putting a reverse mortgage on the house to finance that, because dad's staying there as long as I have decision-making authority. And this is why the power of attorney for personal care is even more important than the power of attorney for property, because the person who holds the power of attorney or court-appointed guardianship of the person is the one who leads the dance and makes the decisions that the attorney or guardian of property must follow. Now, also, if an attorney or guardian of property is making decisions that has an effect on the incapable person's comfort or well-being, then it's not optional. The attorney or guardian must take that into account. For example, the attorney or guardian cannot compromise the person's standard of living for the purpose of preserving the estate for the benefit of the estate beneficiaries.
And so the other duties include that the attorney or guardian of property or personal care must explain their duties to the incapable person, encourage the incapable person to participate to the best of their abilities in the substitute decisions made on their behalf, as well to consult from time to time with supportive family members and friends and persons who provide personal care. So it's not a carte blanche. It's a mandatory requirement to continue to involve the incapable person and their supportive family and friends.
And not only must the attorney or guardian consult with the incapable person's supportive family or friends, they have a positive legal duty to foster regular personal contact between the incapable person and their supportive family or friends. Now, many cases at the Advocacy Center for the Elderly, we've run across situations that reflect a sibling rivalry, where one of the incapable person's sons or daughters or other relatives wants to isolate the older adult from his or her other friends and family. And that is something that should almost never be done. There are situations where an attorney for personal care or a guardian of the person can limit access by the older adult to their family based on safety issues. For example, if somebody poses an elopement risk, or they're feeding candies to diabetics, then maybe there's a ground for some supervision or some limitation. But that's the rare exception to the rule, which is the attorney or guardian of the person should promote regular personal contact.
And another thing that they must do as far as possible is to seek to foster the independence of the incapable person. And there's a duty to follow the least restrictive and intrusive course of action that's available in the circumstances. And that reflects part of the goal of the Substitute Decisions Act, which is to enhance autonomy as much as possible while safeguarding people's rights.
This slide really changes topic to what's broadly known as healthcare consent and advanced care planning. Because, we've often heard of things called advanced directives. Well, in Ontario, there's really no legal document known as an advanced directive. An advanced directive is really just an expression of a person's last capable wish that could change from time to time. The advanced directive document has absolutely no legal effect. It doesn't speak to a treatment provider like a health practitioner. Instead, it speaks to the decision maker, the person named as the person's decision maker for treatment decisions under the hierarchy in the Healthcare Consent Act. And so the substitute decision maker, whether it's a court-appointed guardian, a attorney for personal care, a board-appointed representative, a spouse or partner, a child or parent, a brother or sister, or any other relative, or the office of the public guardian trustee, becomes a mediator or the interpreter of the incapable person's last capable wish. It's the substitute decision maker who has to decide whether the wish was given while the person was still mentally capable, if it's possible to fulfill the wish, if the wish is really the last capable wish or it's changed since then, what the person meant by that wish, and if the wishes apply to the situation, and if there is no last capable wish, then what's in the person's best interest. And so we'll find out in the next slide that Karen will speak to this. The wish can be in any manner. It can be in writing, it can be verbally, it can be something else. They all have equal weight. And if the person goes to their lawyer and insists they have to have a written advance directive, and they pay for the lawyer to write one out and they sign it and witness it. And on the way out of the lawyer's office, the person says, I've changed my mind. Then their last capable wish expressed in the advance directive is no longer their last capable wish. It's what they said after they made the advance directive.
That's right. And so that's why you want to be cautious when you express wishes in a written document, like a power of attorney for personal care. Sometimes people say no heroic measures or this or that. That's not an advanced consent. That's an expression of your wish. And the thing about wishes is that they can evolve. They can change if you get a different diagnosis. You may think without your diagnosis, I could never live with this illness, but when it happens, your view might change. And so it's important to continually have the discussion with your substitute decision maker about your views on your potential treatment and about what you believe in long-term care homes, and to just continue to have that continual discussion with them. And just know that if you put something like that into a power of attorney for personal care, it's an expression of a wish. It is not a consent. And so that wishes, like Graham said, can evolve, and it's the last capable wish that's applicable to the circumstance that your substitute will consider when making a treatment decision on your behalf, or admission to long-term care, or the personal assistive service in long-term care or retirement homes.
And so the difference between advanced health consent and advanced care planning is that, the cardinal rule in Ontario is that a health practitioner who is proposing a treatment has a legal obligation to obtain informed consent before administering the treatment and before anyone else administers the treatment, either from the person who is mentally capable, or if they're mentally incapable, from the substitute decision maker. And so this obligation never goes away. And it doesn't get satisfied by looking at a piece of paper. Healthcare consent is a process in which a health practitioner proposes a treatment. The person who is to make the decision is entitled to get information about that treatment from the health practitioner. And then the person who has the authority to make the decision decides. And you don't get to do an end run around it by someone looking at a piece of paper and saying, oh, well, the piece of paper says this, because how does anyone know by looking at the piece of paper whether it's still valid, whether the person who gave it had mental capacity to give it at the time, whether they've changed their mind since then?
And so in Ontario, advanced care planning means you look at that hierarchy that Graham went through of your substitute decision makers, and seeing who would be the highest ranked in your circumstance, and determining whether, if you really don't want that person, do you have someone you trust who you want to be your attorney under a power of attorney for personal care? Is that appropriate? And just knowing who your substitute would be in the event of incapacity, and then to continue to have that dialogue with them and express your wishes about your future health care, and to continue to communicate your values and beliefs with them. That's how advanced care planning can be done in Ontario. And that can only be done by you, not your substitute decision maker. No one can make a power of attorney for personal care for you. That can only be done by you.
This is our last slide, and we have a number of questions to answer. But before we close this off, there are just a few things I'd like to say about that. The first is that giving the power of attorney, as I said, should always be felt to be an option, not a requirement. If you don't have a power of attorney in place, there will probably be someone else who can make the decision for you. And, I often say this, giving a power of attorney is a little bit like getting married in these ways. Number one, giving a power of attorney is a legal act, just like getting married is a legal act, and you do it in the same way. When you get married under the Marriage Act, you do it in what we call solemn form, which is that both spouses sign a register in the presence of two witnesses, both present at the same time, who sign the register in the presence of each other. That legally is known as solemn form. That's the same way that people commonly make wills in solemn form, where the testator or testatrix signs a will in the presence of two witnesses, both present at the same time, who also sign in the presence of each other. And not coincidentally, that's the same way in Ontario you make a power of attorney. Signed by the person making the power of attorney in the presence of two witnesses, both present at the same time, who sign in the presence of each other, in other words, in solemn form. And this should signify that this is a very solemn and important legal act. Another way that giving a power of attorney is very much like getting married is that getting married can be easier to get into than it might be to get out of. If you were married and the marriage isn't working, you said, how hard can it be to get divorced? Well, maybe not very hard if it's an amicable divorce, no children, financially independent, and everybody wants the divorce, shouldn't be all that difficult. But how difficult can it be? Well, it can be very difficult to get divorced. And so too with the power of attorney document, it's easy to give, but sometimes when you go to revoke it or cancel it or change it, you might find that there's some resistance to you changing it. Your mental capacity might be called into question, and you might end up having to go to court for directions as to whether your power of attorney is truly canceled or not. And finally, if you're getting married, probably the most important thing you need to know about the person you're going to get married to is whether you can trust that person. And if you're not really sure whether you can trust that person, then probably you should not be getting married. And if you want to get married, but you're not sure who to get married to, then maybe it would be better to hold off the whole getting married idea until you're really sure about who you're getting married to. And so too with a power of attorney. If you're thinking of giving a power of attorney to someone, but you're not really sure if you can trust that person, or for some other reason, you're not really sure about giving the power of attorney to that person, then it might be better just to not give the power of attorney at all. And finally, if you do give someone a power of attorney for personal care, that identifies who will make your decision for you, but it doesn't say what your decision is. And it's important whether your decision maker is someone named in a power of attorney for personal care or someone else, your spouse or partner, parent, child, brother, sister, other relative. What's most important for you to do is to have conversations and let your decision makers know what your thoughts are on the important healthcare issues that face you, including admission to long-term care, so that if and when you lose mental capacity to make your own decisions, that person would have a good understanding of what are your last capable wishes that would apply in the circumstance. Because giving the power of attorney is not enough. It doesn't inform the decision maker as to what your values and beliefs are and what your last capable wishes would be. So those are all my comments, Karen. Unless you have something further, maybe we can go to some questions and answers.
Yes, we've just got one question right now. So if anyone else has any questions that they're comfortable writing out, they can pop them into the Q&A box. But the question we've got right before us here is, can I initiate a power of attorney before I am incapable? It doesn't say which kind of power of attorney it is.
If I can answer that, the answer is unequivocally yes. Whether it's power of attorney for property or a power of attorney for personal care, you can make it while you are mentally capable of making your own property and personal care decisions. And that's, if you're going to make one, that's a good way to do it. You can also make it after you lose capacity to make your property or personal care decisions if you still have the mental capacity to give or revoke a power of attorney for property or personal care. But that is a more treacherous route because if you are no longer capable of making your own property decisions or your own personal care decisions, then it could be contentious as to whether you still had capacity to give or revoke a power of attorney for property or personal care. But the thing you need to know is you don't need to give one. If you understand what you're getting into and you've had some advice and you're quite sure this is what you want to do, then fine, do it. But don't make a power of attorney because either you feel you have to, or you're fearing that if you don't make one, it will become too late.
Great, thank you. We've got a couple more questions here. The second one here is, how do regulated healthcare professionals make a determination of capacity related to a treatment decision?
Karen, I could answer that unless you wish to.
Yeah. Well, you can correct me if I'm wrong, but it's the same ability to retain the information and appreciation of the consequences test. So does the person have the cognitive ability to understand the treatment that's proposed? And are they able to weigh the risks and benefits of having that particular treatment?
And to add on to that, the legal test of capacity to make your own treatment decisions is quite clear, but there is no prescribed process for the health practitioner to follow. You know, the decision of the health practitioner is a legally conclusive decision. It's one that can be reviewed by the Consent and Capacity Board, and it really boils down to this: does the health practitioner proposing the treatment hold the opinion that you are mentally capable or incapable of making that particular health care treatment decision? And if the health practitioner forms the opinion by whatever clinical process they follow, that is a legally conclusive decision. If they find that you're mentally capable of making your decision, then there is no review process. If they find that you are mentally incapable of making your decision, then you, as the person who's been found mentally incapable, have the right to seek a review of that finding by the Consent and Capacity Board. I hope that answers the question.
Thank you. We do have a few more here. Because we're talking about capacity, I'm just going to jump down to another question regarding capacity, and that is, what if the presumed incapable person refuses a capacity assessment? What would the next steps be?
Karen, you or I view.
Yeah, that unfortunately, I guess, if they required a guardianship to manage their money, then the route may be at the Superior Court for a court-appointed guardianship, unless the methods that Graham had mentioned before, you know, is the person capable of making their own power of attorney still? Would a trusteeship of their pension suffice? And if not, a court-ordered guardianship. I don't know if there's anything else to add.
No, that's it. And there may be other informal mechanisms. For example, if the incapable person is a legally married spouse and holds joint accounts with his or her spouse or partner, then the spouse or partner may have the ability to manage the accounts as a joint account holder. But if it's an asset that requires legal authority to deal with, such as title to real estate or other financial assets, then if there is no power of attorney for property in effect and the person refuses to be assessed, then it may boil down to a court-appointed guardianship.
Terrific, thank you. There's a question here about, where do I get the information for keeping account of the person's finances when I have a power of attorney for property?
There is a regulation under the Substitute Decisions Act. It's Regulation 100/96, and I think we'll post that link. And it gives a detailed description of all of the record-keeping responsibilities of attorneys and guardians of property and of the person, as well as there is literature available that I think we can point you to the links of through the Office of the Public Guardian and Trustee and other providers.
I'll find those links and post them.
They're very important, because if people understood the record-keeping responsibilities of an attorney or guardian, they might be more informed and sometimes less willing to act as an attorney or guardian. They are extensive record-keeping responsibilities.
Great, thank you. There's a question here about a split family situation where an older man marries another woman, and the second wife has obtained a new will and power of attorney for her husband. The family of the father are worried that the wife has manipulated the change of wills and power of attorney. What rights do the children have?
Well, we're not able to give opinion advice, so we can only speak in general legal information, which is to the effect that if it doesn't matter what the relationships are, if a person makes a new power of attorney for property and or personal care, and the former attorney does not accept the validity of the change, then the person who's challenging the new power of attorney can bring an application to the Superior Court for directions, to ask the court to give directions on which is the valid power of attorney.
And there's a follow-up note here from regarding capacity, and noted that a Section 79 court-ordered assessment under the Substitute Decision Act is another option to the court-appointed guardianship.
The Substitute Decisions Act contains very, very extensive powers in the matter of adult guardianships and guardianship investigations. One of those powers is to make an order directing the allegedly incapable person to undergo an assessment of capacity. And it may also go so far as to an order for the apprehension of the allegedly incapable person. All of those processes are court processes that require court orders that are normally associated with a proceeding in which the mental capacity of the allegedly incapable person is brought into question. It could be an application for directions as to the validity of powers of attorney. It could be, and is normally in connection with an application for the court-appointed guardianship. So you don't get to escape the court process by a Section 79 order, but rather the Section 79 order is a very extensive power that's given to the court in connection with a court process that's brought under the Substitute Decisions Act. And in fact, just as an aside, the public guardian and trustee has the legal authority to conduct guardianship investigations of an allegedly incapable person. And in the course of conducting those investigations, the public guardian and trustee has more extensive investigative powers under the Substitute Decisions Act than a law enforcement agency would have in conducting a criminal investigation under the criminal code as to access to documents, access to premises, and so on, without even court orders.
Thank you. Just a reminder, if anyone has any questions that they would prefer to ask live, you can press the raise hand button at the bottom of your screen there. And we have one more written question here. If a senior has severe mental illness symptoms, such as illusions or delusions, and refuses to go to the doctor or to the hospital, and the only caregiver is exhausted, the senior has no power of attorney and doesn't speak English, what are some options?
That's a very broad and nuanced question that we're not really able to give a categorical answer to, because everything turns on the individual facts. But some of the, depending on the circumstances, some things that could be done could be to try to initiate a statutory guardianship or a court-appointed guardianship. If a guardianship is needed, it may be to initiate a federal income security trusteeship if one is needed. And there may be other informal steps that could be available. But again, this is not a blanket answer to the question, nor is it an opinion. It's simply saying that there are many different avenues, and it will depend entirely on what the factual circumstances are.
I would agree. It doesn't, I mean, the situation doesn't mention if a person's capable or not, or if there's any risk of harm to them or others. There could be various answers depending on those facts.
I think we have one more written question. And a question from Mary Lou McKelvey. How is a power of attorney for property supposed to deal with or work with financial institutions that do not acknowledge or accept the legally drafted powers of attorney for property? Mary Lou, I wish I could give you and everyone else in the room a succinct answer to that. If I could, we could make a lot of money, because there are hundreds, if not thousands, of practicing lawyers in Ontario who struggle with this question every day. You know, when they have a client who holds a valid and subsisting power of attorney for property, and the financial institution gives resistance on accepting the power of attorney. Again, there's no one size fits all answer. It comes down to legal issues surrounding the particular power of attorney and trying to impress on the financial institution that the power of attorney is in fact valid and subsisting, and that they're able to accept it. Well, if we're still on, we're a little bit over time. I think that concludes all of the questions and answers and our presentation today. I can tell you on both my own behalf and that of Karen and our entire staff, it's been a really great pleasure presenting to you. I'd like to thank each and every one of you for supporting our clinic by attending today, and I hope that what we had to say will be of some value to you. Thank you very much.
Thank you.